Case number 116637, State of Kansas v. Derek Lowry.
May it please the court, Tony Cruz on behalf of the state of Kansas, the appellant. I would ask for 5 minutes for rebuttal.
5 minutes is granted.
Just as brief history, this was a traffic stop conducted on I-70. Two occupants traveling in a vehicle traveling westbound. The vehicle was stopped by Officer Blake. During that time period, I spoke to both occupants. According to Officer Blake, both occupants appeared to be extremely nervous. He had Mr. Lowry, who was the driver of the vehicle, accompany him to his patrol vehicle, asked him some travel planning questions. Turned out they were coming from, I believe it was Kentucky, going to Tennessee, going to Colorado. Mr. Lowry advised that he had been out east visiting. Him and the passenger were going to Colorado, and that the passenger was going to end up living and moving to Colorado.
There was some thought about that anyway, that he might get a job out there.
Right.
Does the record tell us how old these guys were?
Yeah.
Does the record tell us how old these two guys were?
No, ma'am.
Okay, I'm just curious. Because my experience personally is that young people often don't know whether they are going to stay in a job or move or whatever, you know.
Sure.
Anyway, so I just wondered if they were 22. Okay, thanks.
I want to say probably mid to late 20s.
Okay.
Officer Blake then went and spoke to the passenger, who advised that they were traveling to Colorado. They would only be staying for a couple of days, and that then they would both be driving back. Based on their stories, also that the vehicle that they were in was owned by a third party who was not present. Given the story of Mr. Lowry that they were going to move there, Officer Blake found it odd that they were not going to return the vehicle, which was newly registered. I don't think it was a brand spanking new vehicle, but newly registered vehicle. That would require the owner to actually have to make arrangements to go out to Colorado to retrieve his vehicle. Officer Blake ended up detaining the two occupants. I believe he had to run home to grab his dog, if I recall. Ran the dog alerted. There was a suppression. The district court found that Officer Blake did not have reasonable suspicion to detain him, and he appealed, and the court of appeals found that the officer did not have reasonable suspicion based on the facts of the case.
Let me ask you a couple of things about the Court of Appeals decision. They said that the license plate reading business and the Colorado as a destination as factors contributing to reasonable suspicion had been abandoned by the state. And I don't see that you've challenged in your petition for review the Court of Appeals determination on those points. So are those off the table?
Yes, sir.
Okay. The other question I had from this was, why were we talking about the officer's airfare research bit when he couldn't confirm the time that he did it? I mean, if he did it after the stop, it doesn't matter at all, and he couldn't remember. So why were we even talking about him looking at that?
Because I think in his affidavit he had put that in there, and so we were trying to figure out if that was the basis for his reasonable suspicion, and he couldn't recall during the suppression motion when he had run it.
So you would agree that since you have the burden of proof on this, that's off the table
Yes.
too? Okay.
Yes. Anyway, the Court of Appeals sided with the district court. I think the district court made some factual findings that were not accurate as to the record, and I believe that the Court of Appeals also followed in suit. There was one of the factors was nervousness. The Court of Appeals cited that mere nervousness does not contribute to reasonable suspicion. However, The officer's testimony at the suppression motion was that this was not mere nervousness, but this was extreme nervousness that he has not commonly viewed with the general public, so it's beyond what he normally sees as mere nervousness. In our appellate courts,
But you heard my question in the first case where I was talking about that as a hypothetical, and that was to set up the discussion here for this case. The fact that the district court, after hearing the testimony, says nervousness isn't a factor, that to me sounds more like a factual determination that we would have to accept as an appellate court coming from the district court. Do you agree with that?
no,
Why not?
because if the only testimony was that it was extreme nervousness, and our appellate courts have found a distinction between mere nervousness and extreme nervousness, that becomes more than just a factual issue, that becomes a legal issue, because are we dealing with just nervousness, or are we dealing with extreme nervousness? And if the district court got it wrong,
Did the district judge just say nervousness and didn't mention whether it was mere or extreme? What does the finding actually say?
I believe it was nervousness.
Doesn't
Just
matter, or isn't a factor, or didn't exist? What does it say?
Just nervousness of the two occupants, and it
Isn't
went
a
on to say
factor? Is that the language? Isn't a factor? Is that the language?
just that.
You understand why I'm asking? Because if the district judge said nervousness didn't exist, that's a factual finding.
Right.
If it's nervousness isn't a factor, then one might argue that was a legal ruling.
Right. And that I don't
Okay,
recall.
we just look at it and see.
Sure.
Thank you.
So there is a distinction that our appellate courts have made between the two, and they are significantly different. Also, there was the conflict of the stories. Whether or not, and I know the Court of Appeals said, well, the fact that they originated out of the same state and they're going to the same state, that's consistent. So how is this not consistent? Well, when you got one saying, we're moving there, or we're living there, and the other one saying, we're just visiting, that we're going back in 2 days, that's a pretty substantial difference.
Wasn't it just about him though? I thought it was just the passenger talking about his own personal plans. Didn't the driver say he worked in Colorado part of the year or whatever? The driver had a job in Colorado, right?
Yes.
So
the driver lived
it's
there.
just the passenger who was talking about his own plans, right?
I believe the passenger said they would both be driving back to, and again, I can't recall if it was either Tennessee or Kentucky, somewhere out east, wherever
Yeah.
they were from.
Yeah.
But I believe that the passenger advised they were both going to be driving back. And then we also have the issue about the third-party vehicle. And I know that the district court said, well, that it was stolen. Well, that kind of misses the point as to whether or not the officer has to have reasonable suspicion of drug trafficking or if a stolen car. And as I cited in my cases, being United States versus Moreno, Ludwig, and I can't even read my last one, but it's in my brief, that the appellate courts have found that third-party vehicles are commonly used by drug traffickers, and is one of the items or one of the factors that can contribute to reasonable suspicion. So what I think, what the Court of Appeals said, well, all of these factors that individually don't really mean much, and they kept it as such. And I think that the district court also made the same kind of analysis of, well, that doesn't mean anything, so we can knock that one off. That doesn't mean anything, so we can knock that one off. And they just went down the line. Well, our case law is pretty clear is that we don't pigeonhole each factor, that you consider them in a whole and viewed in light of the experience of the officer. And in this particular case, that the officer thought that he wasn't, there was more here, and that he was investigating drug trafficking. So I think that the conflicting travel plan stories, the extreme nervousness of both occupants, and the officer had even testified that it was odd that the passenger be extremely nervous because he's not facing any sort of citation, things of that nature. Well, he doesn't have a basis to be nervous or to be extremely nervous. And then we have the third-party vehicle. So given those three factors, there was reasonable suspicion to detain him for the investigation.
So is this another case like our last case in Schooler when the officer says you're free to go, he didn't mean it?
Yes, sir.
So exact same scenario, he was trying to get him to consent so he wouldn't have to go through the arguments that is being presented today.
Yes, sir.
And that was the...
Did he testify to that? That he actually didn't mean it when he said it?
No.
Okay.
But
That was
again,
that was the additional little piece we had in the last.
Right. But-
Which I don't think is in Williams, by the way. I think Williams, he had that activity.
Okay.
But I don't think the court said, oh, and that's okay, to lie in those circumstances. But grist for the next mill.
I was thinking about this in the last case. What if he had given consent and then argued on appeal, I really wasn't free to leave? Wouldn't you be arguing that, yes, he was? Wouldn't that be your position, that the consent, he was able to give the consent because it was voluntary, that the voluntariness had diminished to the point where he was free to go and he gave consent? That's typically how these cases come to us. And wouldn't that be your position here?
yes.
So you would that would be your position that he was. So how's that consistent with what you're arguing here today?
Because, again, that is the subjective intent of the officer is irrelevant. It's whether or not a reasonable person would believe they were free to go or not to give valid consent. If they gave back all the documents to include the driver's license, told them they were free to go, would a reasonable person think they were free to go?
This one actually got told to sit back down in the car, didn't he?
Right.
That's the wrinkle here. This one said no, and then they.
Well, he
sat
said,
back down.
am I free to leave? And he said, no, sit back down in the car.
Yeah.
Yeah. No, you're not. When he said he was. And but you're arguing that if he had given consent at that time, he really was free to go. That's just what you said.
A reasonable person would feel they were free to go.
Even when told to sit in a police car?
Well, up until
That's
that
a
point.
bold person.
No, again, sorry. Up to the point where he was told he was free to go, and if he consented, that would have, the state's position would be that would be a valid argument. Once he was ordered to sit back in the car, he's detained. So he would not be free to go.
All right.
And if the court would permit me, I can.
Let's back up one
sure.
more second. I want to worry this point just one more second. The cases that we referred to earlier today, where a suspect is in custody or is being interrogated at any rate, being interviewed, and the cops say, we got your fingerprints on the glass, your girlfriend's giving you up, all of it a bunch of hooey, designed to get the person to sweat and confess. Those are misrepresentations of fact, right?
Yes.
When an officer who's trained in the law tells a private citizen, here's your ticket, you're free to go, that's not just a representation of fact, is it? It's kind of a legal judgment, isn't it? The officer's opining on a subject about which the officer has special knowledge and that the layperson doesn't, right?
I don't think so.
No?
Because again, this court can always claim no, he was not.
I understand we get the last word
Right. No.
temporarily until somebody in Washington tells us different. But the point is, the layperson doesn't know whether he or she is free to go. Certainly when the officer tells them one way or the other, the layperson's going to look to the officer to know what's correct in that case, isn't it? Isn't that person going to look to the officer? You don't agree with me that has at least some aspect of legal judgment in it, not just a fact like your girlfriend gave you up?
I think there is a distinction because again, that thing is based on the fact of what facts the officer told them.
I'm just talking about you said yes, the officer wasn't really on the up and up when he said he's free to go. Didn't really mean it. And we had that in the prior case too. I'm just trying to, I think there is a distinction, and I want to see if you agree with me, between lying about a fact and misrepresenting a legal reality. No? Especially when one person has expertise and the other does not.
Well, I wouldn't say officers have expertise, because again, I think that we're.
Well, they're
getting-
trained. They're trained to say you're free to go, because if they don't, then the person is still under detention and is potentially transforms into custodial interrogation instead of a voluntary encounter, and it's a whole different set of law that applies. So they're trained in the law in that respect to say you're free to go, to change the legal status of the interaction, correct? That's exactly why they're taught to do that, is to change the legal status of that encounter from a detention to a voluntary encounter.
So they can get into consent.
Well, first of all, they're not required to tell them that they're free to go. That's not even mandatory.
Why do they do it then?
Because we have this.
Because they want to be able to argue later that the consent was
Well-
valid because it was voluntary.
We have this conflicting case law that says, one, officers are not required to tell people that they're free to leave. However, one of the factors that appellate courts review is whether or not the officer told them they were free to leave.
Right.
So to kind of clarify and to try to make a clean break, if you will, that officers will tell people either that you're free to leave or you're good to go.
I understand. Thank you.
The Court of Appeals in this case relied pretty heavily on DeMarco, and it does seem like the facts of this case are very similar to that case. Can you distinguish it?
DeMarco's a 1997 case, and a lot of the cases I cited are post-DeMarco that have reviewed DeMarco and said, we understand what DeMarco said, however, the case law has kind of changed. And in the cases I cited since DeMarco, they have reviewed that, and they have, I'm sorry, I'm mixing up DeMarco and Wood. I'm sorry. U.S. v. Wood, in which I believe DeMarco cites, were both 1997 cases. And the 10th Circuit that has reviewed the Wood case and have cited not only Wood but DeMarco have distinguished that apparently the law has changed in that those cases have reviewed DeMarco and Wood. And as far as the nervousness factor, that I know, I believe it was West or Petit found that two things. One, that DeMarco/Wood dealt with mere nervousness, where they were dealing with extreme nervousness, and also that the officers were able to testify to distinguish the difference between the two. And so I think the case law since DeMarco and Wood has changed as far as whether or not that they're good law as to that portion of it.
But as I understand it here, the district court judge didn't accept the labeling that the officer put on the degree of nervousness, and the court made independent conclusions after watching the video and found that it wasn't extreme nervousness, and pointed to factors like their ability to answer coherently. I mean, a number of factors. So how don't we have to accept that?
I think the court reviews the facts as they were presented to novo. And I believe this court can find, well, the evidence was this was extreme nervousness, not mere nervousness, because all of the testimony of the officer was that it was extreme nervous and not mere nervousness. So I think this court can basically conclude that the district court and the Court of Appeals, as to that analysis, they were.
Let me
That
just make
incorrect.
sure I understand you, Mr. Chris. You're saying that anytime we happen to have video evidence, this court doesn't have to defer to the district court on fact findings? We can find our own facts up here because we have the video?
I think the determination of what constitutes extreme nervousness and mere nervousness goes beyond factual finding. I think it's also a legal analysis that the court can review de novo what the evidence was, not only the video but also the testimony.
I'm not following that, because even the testimony would be factually based. I don't understand how a determination of what the characteristics that are seen and the credibility, in essence, the judge seems to have made a credibility finding regarding what the officer how the officer labeled the nervousness, and felt like the visible evidence from the video contradicted the officer's labeling. So how does that become a legal conclusion?
Because the court can, because I think that you can have evidence to show extreme nervousness, and then the court can find, no, that was just nervousness, not based on anything that was factually admitted at the suppression motion. And I think there is a legal distinction made between mere nervousness and extreme nervousness, that because this court reviews it de novo, the court can look at the video and go, that no, the district court was wrong. And it is a legal analysis as to whether or not that constituted mere nervousness or extreme nervousness.
Can nervousness as a factor that contributes to reasonable suspicion, can the validity of that change over time?
Yes.
In other words, 20 years ago, if people displayed nervousness, it might be unusual. In an encounter with law enforcement, it might be unusual, but in different circumstances, 2018, maybe that's not so unusual.
Or vice versa. Right.
Well, just, I mean, doesn't that really undermine the credibility of this nervousness determination? Ordinary innocent people may be very uncomfortable in a circumstance where they are confronted by law enforcement, right?
Correct. And Officer Blake testified that with his encounters of, and I don't know if he mentioned numbers, but in his experience, the amount of nervousness being shared or that were being exhibited by these two were far beyond what he normally sees, and I believe that goes to he knows the difference between normal nervousness and what he
and that
would
gets
call
to
extreme.
It really puts the point on perhaps what is a legal fiction when we talk about reasonable suspicion being an objective standard. I mean, how in the world is that objective? We're splitting hairs between normal nervousness and excessive nervousness and then extreme nervousness, and you're telling us it's just up to the officer to say where it falls on that spectrum. I mean, that's just pure subjectivity, isn't it?
That's what the appellate courts have held.
That just causes me to wonder whether or not this nervousness factor even makes sense in a reasonable suspicion calculation.
And
Well,
again, I think
it
that's
can't
why.
be that they're just nervous or extremely nervous, but it has to be that then would give the officer reasonable suspicion that there's something in the car to search for. Right? I mean,
I'm
it's
sorry, Judge.
reasonable suspicion. It's not that, hey, this guy's really extremely nervous, so something's going on here. That's not enough. There has to be reasonable suspicion of a particular crime, doesn't there?
Yes, sir.
And that's where my dots get disconnected, is there's all manner of things that may be going on. They may have an outstanding warrant. They may have 2 traffic tickets, 1 more, lose their license. They may be a minority that's afraid of police brutality, or there's all number of things that could cause a person to be nervous, and we're just saying, well, it's unusual, but so what? How does that get beyond the hunch that they may need to search for drugs? And we
Because-
need to get past the hunch.
Because if it were simply the fact that they were nervous or extremely nervous, that doesn't get you to reasonable suspicion by itself. It's combined with everything else to include the third-party vehicle and that the the conflicting stories.
And that's the sum total of what you're arguing
Yes.
today as the totality of the circumstances? Yeah, okay, thank you.
Are there any other questions? Thank you.
May it please the court, Dakota Loomis appearing upon appellee Derek Lowry's behalf. I think there's two separate issues here. One's a factual dispute that the appellant and appellee have. The second is legal conclusions that would be drawn from the factual dispute. First, I think we should turn to nervousness, as the court's been addressing that here over the last 10 or 15 minutes. The district court finding is very clear, found that the appellee, Mr. Lowry, was nervous. There was no excessive or extreme nervousness. He didn't display any signs of dropping paperwork. He was unable to answer questions. He wasn't getting confused by the questions being asked by the officer. So, as to the factual underpinnings here, we have substantial competent evidence to support the district court's finding based upon the testimony of the officer at the suppression hearing, as well as the exhibit of the defendants, which would be the video of the stop. The district court reviewed that video, made a number of its findings based upon that video in terms of the length of the stop, when things occurred during the stop, and reviewed it to determine how nervous Mr. Lowry was when he was interacting with Officer Blake.
Let me ask you on the travel plan discrepancy between the two passengers of the vehicle, or the passenger and the driver. The district court and the Court of Appeals seem to discount that as a significant discrepancy, but it seems to me to be a bigger deal from the standpoint that one of the people is saying both of them are going back, and one person's saying they're staying and going around. The severity of the discrepancy would seem to be a legal conclusion. There's no dispute as to what the two people said. You just weigh it, or you just look at it and say, this is what the two people said. Now, is that a big deal or not in context with everything else, the totality of the circumstances? Am I right or wrong about that?
I believe that the record's very clear about, the factual record's clear about what the inconsistencies were between the appellee and his passenger. In the state's briefs, there's a little, I want to say, maybe perhaps it's being an amalgamation of both inconsistent travel plans and implausible travel plans, which I think that may be a factual dispute about whether there were any implausible travel plans that were discussed. The state refers to that in their brief, but I do think, based upon the record, yes, it's a legal conclusion as to what weight to give to the factual findings that there are inconsistent statements between a driver and his passenger. I would say also that the weight given to those is reduced when you find that there's consistent and verified information that's also given by both the passenger and the driver. There's not only inconsistent statements, but there are also a number of consistent statements between the passenger and the driver. They both are coming from the same location, Knoxville, Tennessee. They both know each other prior to the trip. They know who each other are. They know that that Mr. Lowry works in Colorado, that he has a job there, that he works there over the winter. They know that they're heading to the same ski location in Colorado. And all these things are things that also, I think it's important to note this, already occurred or are in the process of occurring. Where they're traveling from is an established fact. Where they're traveling to, they're in the process of traveling to that place right now. The only inconsistencies are what one person, the passenger, plans on doing once he arrives in Colorado. The length of time he's going to stay there, and whether or not he'll be looking for a job once he gets there. Those are the sorts of inconsistencies that I think are much harder to pin down as being large, glaring signs of reasonable suspicion, given that it's an indeterminate future date that this would be happening, that is not tied to an event that had already happened. For example, I think U.S. v. Williams, one of the cases that the state cites, there's a rental agreement. The passenger says, I'm traveling from Denver, but the rental agreement says it's coming from Phoenix. That's an objective fact on a document that the officer can check and say, wait a second, your story doesn't add up with an objective fact that is pulled out of your vehicle. That's already occurred where the rental car was picked up. There's no, whether or not that is actually true, a reasonable officer would look at this and say, your story does not match up with the facts I have in front of me. In contrast here, you have all the facts that have either occurred or are occurring match up, and so that would reduce the reasonable suspicion that one could place on inconsistencies about future plans, future travel plans in terms of when the defendant or when the passenger was going to return to Knoxville, if they were going to return to Knoxville at all, and whether or not they're going to be looking for work while in Colorado.
Would you agree that, well, first of all, I think you would agree that one of the missions within a traffic stop from Rodriguez is confirming the vehicle registration and making sure that it's not a stolen vehicle or that there's something else going on, correct?
I would agree with that, yes.
And so the second that the officer finds out that the vehicle is owned by somebody that's not in the car, that would reasonably warrant some additional questioning simply to fulfill the mission of confirming proper ownership of the vehicle and proper operation of the vehicle.
I think the mission of the officer at that point in effecting a traffic stop is to determine if the person operating the vehicle is a legal driver and if they have legal possession or have a right to be in that vehicle possessing it. If you have a registration that is in the third party's name, I think it's proper to investigate more fully how this person driving the car came to be in possession of that vehicle.
And that investigation would include asking questions.
I think the investigation could take the form of a computer check, could take the form of calling in license, but certainly could ask the occupants of the car, how did you get this car, where did it come from? There's no dispute about that whatsoever. And in this case, I think the officer did ask those questions and eventually ran the car and found that there was no discrepancies with the statement and that the car had not been reported stolen. There was no problems with the registration of the vehicle. So as to the officer at that point, what the officer knew was that both of the people in the car had agreed as to who the vehicle was, a third-party vehicle, and there's no indication that it was either stolen or some other had been gotten by some other ill-gotten means. Additionally, and for the record, and I think we're talking about this because one of the questions is a third-party vehicle, does it lead to reasonable suspicion that this vehicle is being used in some form of illegal activity? In the record, there's no indication what that illegal activity may have been. Officer testified at suppression hearing, I think on 3 or 4 occasions, that certain things were indicators of criminal activity. There's no indication of what that criminal activity was. There's no specific finding of drug trafficking, of stolen car. Was it this is an indication of they committed an aggravated robbery, this is a getaway vehicle. So there's nothing in the record for you to look at that would tell you this officer's reasonable suspicion is based upon his training experience and in the past finding third-party vehicles being attached to some specific crime. So there's no indication in the record that this was used for drug trafficking, that the third-party vehicle was being used for drug trafficking, because the officer never made any findings in the suppression hearing that that's what his reasonable suspicion was related to. So there's no articulable suspicion of a specific crime that the officer believes either is occurring, is about to occur, or has occurred, tied to the third-party vehicle. Similarly, for the factor of nervousness, and I think Justice Stiegel was getting to this point slightly, while the factual finding, I think it is a factual finding that the district court, that it was just mere nervousness or that the defendant was just nervous. Mere nervousness, a little nervous, very nervous, extreme nervousness, it's hard to determine how much weight to give to that, given you do not know 2 factors. One, you don't know the person you're dealing with in this vehicle. You've never dealt with them before in your life as an officer. So you don't know if this is their normal behavior or if this is something abnormal for them based upon their interactions with you. Second, it's just natural for people who are pulled over on I-70, stopped by an officer, to feel some degree of nervousness. So there's no real probative value to the fact that someone is merely nervous when interacting with law enforcement officers. To answer, I think, a question too that was asked during the state's questioning, the judge in the district court did find, based upon the totality of circumstances, including the nervousness, that it wasn't sufficient to find reasonable suspicion. There was nervousness was not kicked out as a non-factor, which would be a legal issue to address. It was included in there. So the three factors before us today, I think, would be the nervousness, because that was included, the inconsistent travel plans, and then the third-party vehicle. It's the appellee's position, in line with the district court and the Court of Appeals, that the three of those based upon the totality of circumstances, do not rise anywhere near a sufficient level to find reasonable suspicion to detain Mr. Lowry, extend the traffic stop beyond the permissible period to run his license and complete the traffic infraction.
Do we really have to worry about measurably extending the traffic stop in this case? And the reason I say that is because when I have a law enforcement officer point at somebody and say, sit down, to me that's a seizure of the person, and they have to have reasonable suspicion to affect that seizure. And so from the other cases that we were looking at, I don't know that I need to worry too much, and tell me if I'm wrong, about the progression of the questions, et cetera, because I have a point in time that's the seizure, and all I need to do is look at everything that happened before that and decide whether that officer could seize this individual, and not worry even about it took 12 more minutes to get the dog or anything like that. If I can nail it there, then we're done, right?
I think
from your perspective,
I would say that if everything before the moment in which the officer says, sit down, you're not free to leave, if everything before that was part of the investigation of the traffic stop and anything that came out of it, so the third-party vehicle that would be related to that, then yes, we don't have to worry ourselves with what occurred before the detention.
And the reason I'm saying that is you lost those early, you had a couple of issues before that seizure, you lost those, they aren't up here. The question is whether the way I'm looking at the way this is framed, is the question is whether there was reasonable suspicion to seize this citizen.
And my answer, well, based upon the fact that the other issues were, I think, either abandoned or removed, the nervousness, third-party vehicle, and conflicting travel plans, none of those were part of an investigation that extended the duration of the traffic stop, opposed to, and what we're referring to perhaps would be running the license plate reader in Missouri, which has been abandoned, or looking up the Expedia website to see. Those things, I think, under Rodriguez would be extensions, but because they've been abandoned here, we don't have to address those issues, because the three factors that you're looking at come before the detention and are not extended during the initial stop.
Does the you've heard the discussion about the free to leave?
Yes.
Does it play a part in this case?
It does not play a part in this case, only that there was nothing that the officers learned after telling them they were free to leave that would be instructive for the reasonable suspicion analysis.
It did extend the stop, but other than, even then, that's not your argument.
It's not, no.
Yeah, but so in this, the use of this tactic really doesn't play a part in how we look at your...
It does not play a part in this case. I would, to go back to Justice Biles for a second, I would say, though, that the minute an officer is telling someone where to locate themselves, where to stand, where to sit, constricting their movement, a detention has occurred. So clearly at that point, in this case, when he says stay in the vehicle...
Well, particularly after he said he's free to leave and he says no, and he asks for consent, he says no, and then no, then you have to do certain things. That's certainly, I would think, a detention.
And I think it's clear in this case that that's a detention, and there's no disagreement about that. I would also, with my last minute here, point the court back to the fact that while there are cases that allow you to use nervousness, a third-party vehicle, inconsistent travel plans as part of your grounds for reaching reasonable suspicion, the state has pointed to no case where just those three factors alone or combined have been enough to establish reasonable suspicion to allow an extension of detention. Certainly in this case too, you could see that if there was wild contradictions and people had no clue who they were driving with or where they're coming from, where they're going, that perhaps that would greatly enhance that factor in terms of inconsistent travel plans. But in this case, we have a large amount of agreement about about the travel plans, with a few inconsistencies about future events that may or may not come to pass for people who are, as we said, in their 20s. They're carpenters. The pastor's a carpenter in Tennessee, looking for work in Colorado, or potentially returning back to Tennessee. That's a future plan that's really hard to pin down as whether that's an inconsistency or the two people just had different ideas about what they were going to do after they get to Colorado. If there's any more questions, I'd be happy to answer those. If not,
I do have a question. I wrote down, and I believe this is what you said, that there was no evidence of specific criminal activity. Did I write that down correctly?
That's correct. And if you look back through the suppression hearing,
Well, that's all I need right now, because that's the setup to my next question. Was there ever any statement by the officer that said, I believe that there was criminal activity and it was blank?
and the blank would be the type of criminal activity?
Yes, right.
On my close reading of the suppression hearing, there is not. The officer does state, it gives a list of factors that made him suspicious that criminal activity was occurring, and at one point also discussed with the defendant what he sees normally on I-70. On I-70 we make stops like this, and I want to search the car because of these things, and one of them is, I think he mentions at one point, contraband, nuclear weapons or drugs. You've got 1 million pounds of drugs in your car or nuclear weapons in your car. But in terms of this stop and these factors, he did not ever, you can quote me on this, I've read it, that he did not say there's a specific crime that he believed was being committed based upon these factors.
Is that a requirement for him? And if it is, are we not done?
I think it would be, if you have to, for the reasonable suspicion, you have to have a articulable suspicion. You have to be able to articulate what it is that you are suspicious of, what crime is being committed, I believe. So I would say that the officer would need to inform the court what these factors make him suspicious of. If it was a third-party vehicle, he needs to let us know why a third-party vehicle indicates to him that it's potentially being used for this crime. Because again, as the court said, third-party vehicles could be, it's a reasonable suspicious of a stolen vehicle, which is what most of the discussion is about, opposed to being used for transporting some contraband.
Well, there is case law that says a rental vehicle alone can be one indicator of reasonable suspicion. But you're telling me the officer did not make any statement like that, tying these factors into any kind of a crime other than there's something suspicious here.
His repeated phrase was an indicator of criminal activity.
Most people don't lend their car for people to commit crimes with, though, do they?
I'm sorry.
I don't get the connection that you borrowed someone's car and that shows that you're going to commit a crime with it. I'm not going to lend my car to somebody that's going to commit a crime, but the rental vehicle is a little different. You're taking that vehicle out of play for forfeiture.
And I would agree with that, Your Honor. I believe that the fact that in other case law stated this, that the rental cars are clearly, there's a reason why, and testimony of officers has been because of those exact reasons, forfeiture, it can't be tied back to another person potentially who would then have criminal liability. A third-party vehicle.
Well, what I'm saying, the third-party vehicle, once they take stolen vehicle out of the calculus, I don't see how that supports a suspicion that it was loaned to them to commit a crime when we have forfeiture laws that would mean the third party would lose their car.
I would agree with you. Given the implications of losing the vehicle, that seems like it would be an odd decision to make by the person who owns that vehicle.
Any more questions? Thank you, counsel.
Thank you.
A couple of quick things. There was this issue about nervousness, and one of the cases I cited is this U.S. versus Petit case. And it basically says that officers don't have to have a prior acquaintance with a particular person to be able to determine if that they're nervous or not. And again, that goes to be able to ascertain whether or not a person's nervous or more than just nervous. As far as this third-party vehicle, we actually see that quite a bit, where people who are in a common scheme will rent or will borrow somebody else's car because if it is seized, the owner will come forward and go, hey, Joe Smith borrowed it, didn't tell me what for, but I didn't know anything about it. And there is an exemption under the forfeiture laws for the innocent ownership of vehicles that are used or property being used for drug trafficking. I don't know that there is a specific requirement that officers list or name what specific crime that they believe they have reasonable suspicion for under these circumstances.
But you would agree it's not enough to have reasonable suspicion that there's suspicious activity occurring. You have to have reasonable suspicion of criminal activity. Yes. And not just maybe something wrong.
Right.
And so, connect the dots for me here. Nervous, inconsistent belief about what's going to happen in the future on the travel plans, and we're driving a third-party vehicle, which you've clarified would also insulate against forfeiture, and those three all point to what? That this is a getaway car for a burglary, that this is contains a weapon and one of them's a felon, has drugs, there's outstanding warrants, there's the next traffic ticket's going to be lose your license. What does that all point to?
Given these facts, I think it's drug trafficking, and I think even though the officer doesn't specifically say that specifically, I think given his line of statements to Mr. Lowry, that's what I believe was happening after he was detained.
Well, that's why we require particularity, because we don't allow fishing expeditions, right?
Correct.
Okay, excuse me, Chief.
No, I was just going to follow up on that. Is it up to the court then to decide under these facts what particular criminal activity may have been underway? If the officer doesn't tell us, is it up to the court to try to make that determination, or does our inquiry in there and say if the officer doesn't tell us, then we're done?
It would have been much cleaner, if you will, had the officer testified what specific crime he was investigating after detaining him. However, I think this court can look at the factors outlined in the state's brief and show that this is typical drug carrier behavior.
We can arrive at a legal conclusion. We can arrive at a legal conclusion.
I believe the court can look at the other cases that have the exact same facts, if you will.
And the standard's reasonably articulable suspicion, not articulated. So if they're asked, they better be able to answer it. But if they're not, okay.
Thank you.
Any further presentation?
A quick question. I know there's been this issue of whether or not officers can tell the drivers that they're free to leave and then that they're detained. Would the court permit me to supplement with some case law to show that's permitted?
poll my colleagues, is that going to be helpful for our discussion this afternoon when we're conferencing this case?
Judge?
I'm asking, is that going to be helpful to us? We're going to start conferencing at about 1 o'clock. That's an hour from now.
That I can provide the court
Not if
with
it's
that.
not a part of the record, I'm not, no,
Okay.
No. All right. Thank you.
it's a part of it.
Court will take this matter under advisement. We thank counsel for their arguments.